Hi, my name is Andrew Meinzer of Meinzer Law Firm. In 3 prior videos, we've discussed how to give notice of a court hearing in the probate division of the Los Angeles County Superior Court in California. Here we'll discuss some exceptions to those notice requirements. There are 5 exceptions that we're going to discuss briefly. 1, waiver of notice of hearing. 2, appearance instead of notice of hearing. 3, appearance instead of citation. 4, notice of continuance. And 5, ex parte court hearings. After you file a petition or other pleading with the probate court, you need to have someone mail a notice of hearing to everyone entitled to notice in that case. If you forgot to mail notice of hearing to someone and now it's too late to do it, there are 2 possible fixes. First, consider having that person who didn't receive notice sign a waiver of notice. This can be a good option if that person is not adverse to what you're requesting of the court. There's another possible fix if you forgot to mail notice of hearing. If that person who didn't get notice appears or shows up during the court hearing, then the fact that that person didn't receive notice becomes irrelevant. Mailing the notice of hearing is for letting other people know about the court hearing. If they appear in the court during the court hearing anyway, then no harm, no foul. So in that circumstance, you haven't mailed notice to somebody. Another option instead of waiver of notice is just encourage them to go to the hearing. And if they actually show up, that would be fine. Now, in a conservatorship case, you need to personally serve a citation for conservatorship and a copy of your petition on the person who is the subject of the conservatorship, and that person is known as the proposed conservatee. Personally serve means physically handing to that person, and as with the notice of hearing, you can't do it, somebody else has to do it. If you didn't accomplish that personal service in time, the court-appointed attorney for the proposed conservatee may waive it. So that's one option. Another option in that situation is if the proposed conservatee appears during the court hearing, that will make the failure to personally serve that person irrelevant. Now sometimes you get to court, you did all the notice fine, and you go to court, and for some reason the judge wants to continue or postpone the hearing to a later date. Normally in that situation, you do not need to provide notice again of the new continued hearing date. Once you've given notice of the first hearing, as long as it was all adequate, the notice, normally you do not have to give notice of the continued hearing. Now, the court very strongly prefers not to have hearings unless everyone with an interest in the petition and what's being requested has the opportunity to provide pertinent information to the court. That's what the notice is all about. And it's fundamental to the probate court providing justice. Nevertheless, there are certain emergency circumstances when the court will allow a hearing without all of the regular notice requirements being satisfied. And these kinds of hearings are called ex parte court hearings. Ex parte essentially means in the presence of less than all of the interested parties. It can be difficult to take advantage of all these exceptions to let everyone know about your court hearing. If you do it incorrectly, then the court could continue the court hearing to give you time to do it correctly, or worse, the court could even deny your petition altogether, and then you might have to start all over again. And that's why having an attorney with experience in the Los Angeles County Probate Court helps you avoid all of these potential problems. Again, my name is Andrew Meinzer of Meinzer Law Firm, and we have over 20 years of experience in the probate division of the Los Angeles County Superior Court. So please call us, even if you just have a question, and let us take care of you.